All right, gentlemen. So you went through the whole process. You somehow made your way through the tangled web that is the federal court system, and you were selected amongst the thousands of applications to get your case before the United States Supreme Court, and you are now there. You've made it to the show. What is it like here in the pros? Well, it's nothing like what you might imagine. Well, I don't know what you might be imagining. The issue being, if you think that court is anything like what you see on TV or the movies, you are going to be horribly disappointed. The Supreme Court is even less exciting, I think, in some ways, because it is so rigid in its structure, and it has to be, because basically every case has to be treated the same and has to go through the same due process. We also have to, again, keep the workload to a manageable amount. We can't let things drag on forever in the United States Supreme Court. So we're going to walk through a process that is a little rigid and robotic at times, I think, at least in the attitude of many people. You know, we have this idea that here at the Supreme Court, decisions which will affect the 330 million Americans are made. You know, Roe v. Wade, Brown v. Board, groundbreaking cases which can change the entire fabric of our country. And I think we like to imagine that there are these eloquent soliloquies, and you know, I always like to reference that moment from the movie A Few Good Men where Tom Cruise's character, demands, "I want the truth," and he gets the epic comeback of, "You can't handle the truth." Yeah, none of that. Yeah, you're not going to get any of that. Court in general is dry and dull. The Supreme Court is extra dry and dull, I think. But again, it has to be, right? We're trying to make legal decisions. We're not making theater. All right, so sorry for that long interlude, or introduction, I guess I should say. First of all, the court is not working 365. The court is in session roughly 36 weeks every year, from early October until the end of June. During those 36 weeks, the justices will be reading briefs in their offices. They will hear oral arguments. They will then debate and render their decisions. They do a lot of time in the conference room where only the judges are allowed to be. No one else is allowed to be in the conference room when the judges are debating cases with one another. Most cases, of course, get to the Supreme Court because because of a writ of certiorari, as we talked about, where basically the court requests that this case be brought to them. The case is brought to them in the form of briefs. The lawyers for each side in a case will present a brief, which, as you can kind of get an idea, it's a brief summary of everything. It basically is supposed to give the judges a relatively simplified version of the events, the lower court decisions, arguments, facts of the case. Basically, it's supposed to give them kind of a Spark Note or Cliff Note version that they are supposed to, from there, kind of come up with what questions they might have, what things they need to have more fleshed out. All right. So then, basically, they schedule when the case will be heard before the Supreme Court. Okay? Both sides will go and present oral arguments, and it's just the lawyers. It's just the lawyers. You're not going to have a whole slew of people in there. You're not going to have all these characters and witnesses. Again, it's a very regimented process. So what happens? The two sides show up. The lawyers from the two sides show up, and they will present their oral arguments to the court. They will usually summarize their brief. They will emphasize certain points. They are strictly limited on their time, basically a half hour. You do have a podium with two lights on it, though. There's a white light that comes on, that's your 5-minute warning. When the red light begins flashing on your podium, you must stop speaking immediately. You're out of time. Let's be honest, you know that those lawyers set a watch on the lectern, and they are fully aware of how much time they have. It's not like the white light comes on, they're like, "Oh, I've got 20 more minutes of talking." They've prepared. You know this, right? You've been told in advance you're coming to the Supreme Court. It's not like they tell you on Monday, stop by on Tuesday. You've had weeks to prepare. They have got this down pat, right? They're going to get everything they need to get out in 30 minutes or less. The justices will ask questions. This is their opportunity to get answers to some of the details that they might feel were left out of the brief, or things that they don't feel were covered enough in the brief to give them a full understanding. And so sometimes the judges will ask very straightforward, sometimes searching. Sometimes they're kind of open-ended, loose questions, trying to get a little more, pry out of the lawyer in sort of a kind of vague sense, right? See where they're going to go. I do want to mention that since the United States government is involved in about half of the cases that go to the Supreme Court, either as a plaintiff or a defendant, about half of the cases before the U.S. Supreme Court involve the United States government. That means that the government's top lawyer is there half the time. The Solicitor General of the United States of America is the third-ranking officer of the Department of Justice. He is below the Attorney General and the Deputy Attorney General. A matter of fact, the name I've mentioned several times, Robert Bork. Robert Bork, who was nominated to serve on the Supreme Court in 1987 by President Reagan and was voted down, he was Solicitor General in 1973-74 when Richard Nixon started basically trying to cover his tracks. And so Robert Bork actually served as Solicitor General, so I'm just mentioning a name that has come up before. But if you are looking to be America's lawyer, you honestly are looking to be the Solicitor General. You will be the man representing the United States government before a case involving the Supreme Court. The Solicitor General actually decides what cases the government will appeal and personally approves every case that the government presents to the Supreme Court and then presents it. Now, in addition to the arguments that are made by the lawyers, okay, there might be briefs or perhaps oral arguments made to the court in the form of amicus curiae, which means a friend of the court. So you might get an amicus curiae testimony or an amicus brief. These are things that are requested by the court ahead of time. Again, it's not like you show up and then they're like, do you have anybody in the hallway that might be able to come talk to us? You know ahead of time. Great example. And it's a case we talked about previously when we talked about civil rights and civil liberties, actually civil rights. But the case of Bakke, I don't know how many of you guys remember, but Bakke versus the Regents of the University of California. Bakke was basically the case where they talked about quotas, and basically a white guy argued it's not fair that he was denied admission to medical school because of strict number quotas. In the case, Alan Bakke, again, who was claiming basically he was a victim of reverse discrimination, 58 amicus briefs were filed to the court. And so basically there were 58 briefs that came along with Bakke's that were either students who were like him, similar, almost like a class action lawsuit, right? But people providing testimony or stories similar to his, trying to highlight to the court that this is more than a one-off kind of situation. I do want to point out, before such briefs are filed, both parties must agree, or the court must grant permission. And so, again, it's not the kind of thing you just drop on their lap. It's the sort of thing that is agreed to by basically all parties involved ahead of time. I know some of you are like, if I was the other side, I would never allow an amicus brief. Well, it's a double-edged sword. If you want to be able to submit amicus briefs, you have to allow the other side. You both have got to agree. Also, if the one side wants to submit it and you refuse to allow it, they will let the court know that you turned them down, and then the court might actually ask a few questions, and then the court might say, no, we want them, okay? Sometimes I would like to also say these briefs do shed new light. They aren't just repetition. But regardless, you're going to have the lawyers up there presenting. There might be someone who comes up there to give testimony as a friend of the court. There might be additional documents from outside sources. But by and large, it's a very regimented, regulated process, okay? For those of you who are thinking that this is the only way that the court is able to do anything, or, you know, this is it, right? Think about it. The judges are going to, they are going to take time after they get your initial brief, okay? After the writ is issued and the briefs are submitted, there's going to be a time period between the submission of the briefs and the oral argument presentation. It is during this time period that the judges and their clerks are going to be pouring through all sorts of legal precedent and documents and law reviews and statements and cases, trying to get a full picture of the situation, okay? The Harvard Law Review, the Yale Law Journal, other Supreme Court cases in the past, or, whatever, okay? And so it's not just your brief and you're a lawyer, is my point. That is not all that's coming to bear. Supreme Court judges are going to use the vast array of legal documents and precedents available. And again, that's where clerks come in handy. They might even contact, now they can't give all the details, they might contact prominent law professors, legal scholars, people who specialize. They will call members of the Harvard or Yale faculty, law faculty. They might contact a mentor if there's one still out there for them. Hey, broad details, what do you think? And get some insight, right? Every Friday is debate and vote day for the Supreme Court. So every Friday, the judges go to their conference room where they will debate the cases that they heard during the week. Now, there is a very strict order to this. The Chief Justice speaks first, okay? So the Chief Justice will give their opinion of the situation first. Then we give our arguments in order of seniority, okay? So Chief Justice John Roberts will speak first, and then he is followed by, I know your book said Anthony Kennedy, but Anthony Kennedy actually resigned after your book was written. So it's no longer Anthony Kennedy. The next most senior is Clarence Thomas, okay? So Chief Justice Roberts will speak first, followed by Clarence Thomas, Ginsburg, Breyer, Alito, Sotomayor, Kagan, and then after Kagan is Neil Gorsuch, who was named to the bench April 10th, 2017, to replace the vacancy by Antonin Scalia, I apologize. And then lastly to speak is the rookie on the team, Brett Kavanaugh, who was named to the court October 6, 2018, and he replaced Kennedy, who resigned. So you go in order of seniority, right? So longest serving judge gets to speak first and give their opinion, right? The idea is doing this. Well, hang on before I explain all that. Okay. Everybody gets to give their 2 cents. Then we vote. We vote in reverse order. So that means that Mr. Kavanaugh is the first judge to vote, and then Gorsuch, work our way back up. And that means that the final vote will be the Chief Justice, which means the Chief Justice, if there's a tie, he will decide it, right? There's another nice thing about the Chief Justice going first in the debate. It means he can kind of set the tone. He can kind of guide it. His opening statement, like any opening statement, kind of sets the tone and the direction of things. And so he's got incredible influence in the vote because his vote will break a tie. And in debate, he kind of sets the tone. Now, let's say that there is a tie, okay? If there is a tie for some reason, because obviously we had an 8-member court for a while because Scalia died and was not immediately replaced. We also have cases where judges have to recuse themselves. There might be an instance where a justice says, look, I cannot be involved in this case because I have some sort of conflicting interest. For example, Elena Kagan in 2016, there was a 7-vote court because Scalia was dead, but Justice Elena Kagan had to recuse herself because she said she'd worked on this very case as Solicitor General when she was serving in the Obama administration. And so she said, look, I have stake in this case. I shouldn't be part of it, right? So she stepped back. And for those of you who are wondering, the Supreme Court was originally 6. From its creation and to the Judiciary Act of 1869, it was a 6-member court. So there were a lot of opportunities for a tie vote for the first 80 years the court existed. So if there is a tie vote, that means that the lower court ruling stands. Right? So if there's a tie, whatever the previous ruling was stands. It is not overturned. It just, that's the way it is, right? Okay, so when they vote, okay, let's assume there is a majority opinion. All right, let's say there's an opinion. The court issues a written opinion explaining its decision. All right. Sometimes the opinion is very brief and unsigned. This is called a per curiam opinion. Per the opinion of the court, all right? Sometimes this is quite long and it's signed by the justice who agree to it. Basically, if it's a no-brainer, we just needed to get this out there. It's very quick and brief and easy. Sometimes it's long-winded, all right? Sometimes it is pages upon pages because they've got to explain themselves, right? If the Chief Justice is in the majority, he will write the opinion or assign the task to one of the judges who agreed with him. If the Chief Justice is in the minority, the senior justice on the winning side will write the opinion. Okay? Now, so let's just forget a per curiam opinion. All right? Again, a brief unsigned opinion. They didn't feel it. Let's say, again, it's a no-brainer, and let's say it was a majority or a unanimous vote. They're going to write a real quick, this was our ruling, this is why, thank you, okay? But let's go to the bigger ones, all right? Let's forget the per curiam. There's an opinion of the court, which is the majority view, okay? There is a concurring opinion. An opinion by one or more judges who agree with the majority conclusion, but for a different reason, and they wish to explain it. So they voted on the majority side, but not for the reason that the majority is saying, right? Like, let's say it's a 6-3 ruling. And let's say that 5 judges all had the same reason why they voted the way they voted. But there's this one judge, the 6th vote, who voted the same way, but for a very different reason. And they feel like they need to explain that reason. They can write what is called a concurring opinion. And then there is a dissenting opinion. The opinion of the justices on the losing side. Now, this is where clerks come in handy. As I've said, justices have 3 or 4 clerks that are working for them, and clerks oftentimes help write these decisions for the opinions. You know, they help carve out a brief, I don't know what just happened there. They write out a brief statement or a rough draft usually, and then it gets polished by the justices. Now, I do want to point out that many Supreme Court decisions are unanimous. About 40% of them actually are unanimous. It's clear-cut, it's not difficult, and that's when you get a lot of these per curiam decisions, etc. But for the remaining 60%, it's oftentimes dicey. And there are 2 main voting blocks. Well, your book talks about there were 2 main voting blocks and 1 swing vote. Okay? The conservative bloc was made up of Samuel Alito, John Roberts, and Clarence Thomas. Antonin Scalia was also on the conservative bloc. Okay? The liberal bloc, when your book was written, was Breyer, Ginsburg, Kagan, and Sotomayor. Not shockingly, those were all the judges that had been appointed by Democratic presidents, right? The swing vote, though, was Anthony Kennedy. And again, he has since retired. But Anthony Kennedy was appointed to the court by Ronald Reagan. He is a conservative judge. But he voted conservative on criminal law. But on other issues like abortion, gay rights, Guantanamo Bay, he voted with liberals. So Anthony Kennedy was kind of the toss-up. You know, you had 4 who tended to always vote the same way. You had 4 who tended to always vote the same way. And then there was Anthony Kennedy in the middle, and nobody knew where he's going. Again, your book was written just 3 years ago, but what it changed 4 years ago. But what it changed 4 years makes. Kennedy is no longer on the court. As I said, Scalia, deceased. Both of those men were replaced by more conservative-leaning, and so I feel that Kavanaugh is likely to be more conservative than Mr. Kennedy, who he has replaced. Neil Gorsuch a little more likely to be like a Scalia. So what we're looking at is probably a court that's going to go 5-4 for a while. Not guaranteed, but a little more 5-4. but more consistently 5-4, right? All right, now, yeah, and as I was trying to say, this is the Supreme Court in 2015. Here is Antonin Scalia, who passed away in early 2016, and here is Justice Kennedy, who again retired. Kennedy, born in 1936, older gentleman, wanted to have a little bit of time without all the work. Although Ruth Bader Ginsburg, born in 1933. I'll go ahead and rattle this off really quickly. Clarence Thomas, born in 48. Ginsburg, 1933. Breyer, 1938. So Breyer is not a young pup either. And then you've got Alito, 50, Sotomayor, 54, Kagan, 60. If you're curious, Neil Gorsuch was born in 67, and Brett Kavanaugh in 65. So I would assume, I know that this is gruesome, that we will either lose Justice Ginsburg or Breyer might retire in the not-too-distant future. I don't know, though. As I said, I think, I have not said this. I don't see either one of them really leaving, though, because like I just said, the court is 5-4 conservative right now. You've got a Republican president. You've got a Republican Senate. I don't see either one of these liberal-leaning judges bowing out voluntarily, because that would open the door to, and let's just go ahead and say right now, let's say that Donald Trump wins re-election in 2020, right? You got 4 more years of a Republican president. A good chance you're going to have a tied Senate or a Republican-leaning Senate. And so if I'm the liberals, the last thing I want to do is open the door to 2 more conservative judges on the court. But anyhow, I'm just spitballing at this point. But there you go. There's your Supreme Court. Now, why is it important? You just kind of gave me this really dull Supreme Court story. Why is the Supreme Court story important? Well, the Supreme Court has the ability to make law without making law, right? They aren't able to actually pass laws, but they can strike down laws, and their rulings also can interpret law and tell the government how a law is to be enforced or carried out or to what level, etc., right? And so the courts make policy. They really do. Whenever they interpret the law, okay, they are changing the way law is carried out, the way law is enforced. Here's one way you can look at it. More than 160 federal laws have been declared unconstitutional over the history of the United States of America. That means that 160 times something passed by the United States Congress was shot down and removed by this small body of unelected officials, right? Another measure is the frequency with which the Supreme Court changes its mind, as your book said. Okay, an informal rule when it comes to courts is what is known as stare decisis, which roughly means let the decision stand. It's the principle of precedent, gentlemen, right? A word that I've used numerous times in this course. Historically speaking, courts are more likely to go with precedent than they are to go off and do their thing, right? And so there is the tradition that the court is going to hear a case and it's going to just rule. If the case is not groundbreaking enough or something hasn't changed enough, they're going to go with tradition and with precedent. That's why, digging up old cases, if you're a lawyer and you're trying to win your court case in the Supreme Court, you're going to try and find every example and slip every example in your brief you can of examples from the past that look just like your case. But there are reasons why precedent is important beyond stare decisis. The first being, if law is constantly changing, then judgments in law will become incredibly unpredictable, and it will become incredibly difficult to deal with anything. It will be incredibly difficult for anything to be consistent in our legal code, right? And so it is not just, oh, we like tradition. It's the sense of, if we don't have some form of consistency in our legal decision making or in our judgments, then the law system will become this unwieldy, chaotic free-for-all, right? And no one will really know how anything is being done or handled. Now, another reason why it's important that we have this tradition of precedent. If we believe in equality before the law, we have to have a tendency towards precedent. We have to be able to say, look, my case is incredibly similar to all these other cases, and you ruled this way in all those other cases. If you rule differently from me, you are treating me differently. I am not getting my fair treatment by the court. So that is another reason why we have a tendency towards precedent. But the court has overruled itself, right? The court has overruled itself on more than 260 cases since 1810, right? They've ruled one way, and then several decades later, they rule another way. So the court has actually countermanded their own rulings before. A great example would be Plessy v. Ferguson and then Brown v. Board. That's the easiest one off the top of my head. But the Supreme Court said segregation, separate but equal is A-OK. And then, like, less than 60 years later, they were like, yeah, no, you can't do that, right? I mean, they do that. Now, a third thing you have to consider when looking at the Supreme Court, right? So, the Supreme Court is getting into issues it never got into. This is another reason why the Supreme Court is more important than it was in the past. The Supreme Court, when it was first created, we talked about this, nobody really gave it much emphasis. Nobody gave it much credit. They didn't even have a home. When the Supreme Court was first created, they did not have a standing court, like a building all their own. They kind of bounced around in the early days. It wasn't until basically almost 20 years into the game when John Marshall, took the court, he made it into an institution that people respected. And as time has gone by, the court has gotten more and more into issues that used to be political, is where I'm trying to get with this. Once upon a time, the court looked at things and they were like, that's not a legal question, that's a political question, right? For a while there, the court refused to hear cases about congressional districts, right? And how they were drawn up and the size and population. That's not our issue, that's the Congress's problem. And then in 1962, the Supreme Court decided it was time that they handled it because they felt it wasn't really a political question anymore. It was now a civil rights question, right? It's about representation and being treated fairly in the eyes of the government and the law, etc. That's where you get things like, Roe v. Wade. Is this a legal question or a political question? They were like, no, it has to do with privacy, and that's a legal question, not a political question. And another way you can measure the influence and impact and importance of the Supreme Court, especially in the modern day, is the remedy. How does the Supreme Court expect its rulings to be carried out or enforced, right? The remedy is the judicial order of how the enforcement or repair of a wrong shall be done. Now, for example, in an ordinary case, it's easy. I sue you, I win, you pay up. Right? It's real simple. But the remedies that the Supreme Court pushes forward sometimes are sweeping. They are vast. First of all, most of these cases are not involving one person or one entity or one institution, but a myriad of folks. Your book gave the example. A federal district judge in Alabama heard a case brought by a prison inmate in the state. And basically the Supreme Court eventually ruled, or the courts eventually ruled, yeah, the state of Alabama needs to improve their prison system. That affected tens of, and it eventually went on to a higher level. You are talking about millions of dollars, you're talking about thousands of people, you're talking about multiple institutions, you're talking about having to change all these things, right? It wasn't just that guy needed an improvement in his prison facility or his prison experience. Every person in the same experience is being held in what is considered an unacceptable condition. So they've all got to change, right? And so this means that, again, the Supreme Court, again, Brown v. Board, it wasn't just Linda Brown. It's every African-American student in the United States of America who's going through the same situation, right? And so the Supreme Court can change, the remedy can end up affecting the entire country, right? Now, this will lead us to the wonderful question of judicial activism, right? And this is where liberals and conservatives love to lock horns, right? Not that they love to lock horns, but it's where they get into their biggest argument and debate. There are those who support judicial activism and argue that the federal courts, they have a responsibility to correct injustices in society, to correct the failures of the other branches or the states. When the legislative and executive branches fail to do their job, it's the court's job to repair that, right, and to fix it. But then there are people who say, no, right? Judges, they are judges. They are not legislators, and they aren't experts in anything but being a judge. That is one thing, For you to stand up, judge, and tell me that we're running our schools improperly, who are you to do that? You're not an expert in running schools. You're not an expert in running prisons. You're not an expert in any of these matters. Who are you to tell me how to do this? You can tell me maybe that I'm not doing it according to the law, but for you to then turn around and give me this remedy, right? Who are you to do that? And that is an argument, I didn't elect you to do that. I didn't elect you school superintendent, so don't tell me how to run the schools. I didn't elect you to run the prisons. I didn't elect you to do whatever, the tariff law, this tariff's unconstitutional or whatever. All right, well, let's let the people at the whatever, whoever isn't responsible for coming up with that stuff, come up with a new answer, and then you can tell me if the new answer is legal. But it's not your place to tell us, right? You are not a legislator, and you're not an expert in any of these things. That's another thing. People don't like the fact judges aren't elected, right? They're not elected. They're chosen, and then they sit there for life. That's the other thing. They don't have to worry about the opinion of the people. They can't be fired as long as they don't do anything illegal, right? They can do whatever they want, and the rest of us just have to accept it. Some people don't like that about the judges. And now, much like the Supreme Court, I'm going to kind of go back on what I just said in a way, though. It's an oversimplification to claim that judges don't care what people think. They're not running for re-election. They don't have to worry about their job. They just, they sit there in their stupid robes in their private conference room doing whatever. It's not true. The judges, federal judges, understand the public opinion is important, not for their job, but it's our law. It's our law code. It's our society. And they are fully aware that they have to make rulings that fit into the world in which we live. And that their job is to interpret our laws, right? They're not off making their own society. They also are fully aware that the only way they're going to get anything accomplished is if they have the support of the people and the government or whatever. The judges have no police force or army, as your book mentioned. If you remember your American history, Worcester v. Georgia, when John Marshall said you cannot kick the Cherokee off their land, federal government, right? You're violating a treaty. Andrew Jackson famously said, Mr. Marshall has made his opinion, now let him enforce it, pointing out a great problem if you're the Supreme Court. You can say whatever you want. You're at the mercy of the government to actually enforce it. You're at the mercy of Congress and actually, more specifically, the executive branch to get anything done. And so, judges are fully aware that the decisions that they make can be resisted or ignored, especially if people don't care or if they think they're big enough to get away with it or whatever. Long after the Supreme Court issued their ban on praying and Bible reading in schools all over the country were still doing it, right? Schools were still starting the day with prayers and there were Bible readings. Schools were still segregated well into the late 1960s in some places. Schools were finding ways to avoid desegregation. I mean, famously, the governor of Arkansas refused to integrate a school at one point. We're all aware that, Governor Wallace stood on the steps of the University of Alabama. I mean, people have stood up and fought decisions by the court. The question is, how far are they willing to go? Are they willing to run the risk of contempt of court? Are they doing it just for show? Whatever. Okay? But there are times, too, though, when the Supreme Court, quietly gets ignored. When the Supreme Court declared the income tax to be unconstitutional in 1895, people promptly ceased trying to collect income taxes. When the court in 1952 declared it illegal when Harry Truman tried to seize the steel mills in order to stop a strike because he was afraid it would stop our ability to fight the Korean War. Harry Truman just said, okay, yeah, you win. It depends. Some people will fight. And they'll fight long and hard because they think they won't haul me into court or I've got the backing of public opinion, and they're wrong. And other people realize, yeah, it's a fight I'm not going to win and it's not worth it. Harry Truman was not about to fight the Supreme Court over that. So it just varies. Some people will abide by the court. Some people will resist it. And that's something the court has to take into account. Right? They have to take into account, what is the situation? Will we be supported? Do we have the people? Do we have the government? Can't just go rogue. Now, Congress, by the way, has some control of the Supreme Court, or the courts in general. For one, as we all know, you don't get to be on a court until the Senate confirms you, so that's obviously the first way that they can control the courts. The Congress can impeach judges, all right? 15 judges have been impeached over our history. 9 others have resigned before those proceedings could occur. Of the 15 who were impeached, 8 were convicted, 4 were acquitted, and 3 resigned before the trial actually took place. In 2009, U.S. District Court for Southern District of Texas, Samuel Kent, and in 2010, Thomas Porteous were convicted by the Senate and removed from office. So we have had several. Porteous, if I remember, was a federal judge from Louisiana. They were both convicted of campaign finance or like embezzlement, some sort of financial whatnot. But let's be real. Confirmation and impeachment proceedings are not the way that we keep judges in line. That's not the way you regulate the judiciary, because let's be real. Once they're on there, as long as they're not a fool, you have no control, right? But honestly, another way that the courts in general are handled is through altering the number. There is no actual law, again, that says how many judges have to be anywhere at any given time. It's up to Congress. I just told you a moment ago. They increased the size of the Supreme Court in 1869. I mean, they didn't have to. They decided to. Franklin Roosevelt, as we talked about previously with his court packing plan, he tried to. In 1978, Congress passed a bill to create 152 new federal district and appellate judges because they felt it was overwhelmed and overloaded. In 1984, an additional 84 federal judgeships were created. In 1990, another 72 federal judgeships were created. Changing the size of the judiciary has occurred over time. Now, that is one way, again, that the Congress tries to control the judiciary. Just create a bunch of new judgeships and then we'll fill it with people. Sometimes they just pass a law after it's been struck down. Your book mentioned on 30 occasions, Congress has merely repassed a law that the court declared unconstitutional, basically banking on, we'll see if this goes back. We'll see if it gets appealed again, or maybe it's just a forget you, court. We're going to do what we're going to do. One great answer is to amend the Constitution. If they're like, it's unconstitutional, all right, well, we'll just change the Constitution. Take that. But one of the most powerful sources of control of the federal courts is to decide what jurisdiction the lower courts and appellate courts and Supreme Court shall have. Basically, just changing the rules for who's going to get what cases. That's one way that the Congress has tried to finagle or manipulate the role and influence of the courts. That is, if you don't want it to get into the federal system, you just don't make it a federal crime. And again, it would have to go through state court and be appealed from state Supreme Court before it would ever go to the federal courts. And by then, you're basically asking something to pass through like 3 hoops and then somebody kick it up. So again, that's another way that the Congress has tried to limit or manipulate the role of the federal court system. You just try and change who has original and appellate jurisdiction and at what point. Now, if you're curious, the approval rating for the court has varied over time. Dred Scott was a horribly unpopular decision. Depending on where you lived. If you're in the South, you thought it was awesome. If you lived in the North, you thought it was an abomination. That means a good percentage of Americans didn't like Dred Scott when it came out. The opinion of the court ebbs and flows, just like Congress, just like the president, although Congress is usually consistently low. But the approval rating of the court ebbs and flows. Now, I do want to point out, too, when we say opinion, you have to keep in mind, are we looking at the overall opinion or the opinion of the most highbrow and elite in America, right? I do want to point out, opinion of the court tends to go with the opinion of the government in general and the president's approval rating. As you can see up here, 61% approval rating of the court system in 2009, but that's, Barack Obama's honeymoon period. And everybody was all, yay, and loving each other. In that kind of muddy waters that we were in with President Bush at one point. In 2005, you can see it was lower. And so, as I said, the approval rating for the courts seemed to reflect approval of the government as a whole, because we tend to take that oversimplified view. If it occurred, the courts somehow had to be okay with it, right? If the government's doing stuff that is not popular, people take this kind of oversimplified view that, obviously the courts were okay with it. They let it occur. Which, of course, is not entirely accurate, but regardless, that is what people tend to do. Now, I do want to point out that the court, there are going to be personnel changes, and they aren't that often, right? That is another issue that you're going to face with the court. So, the courts obviously change. Your problem is they change so irregularly, right? And sometimes they'll go, decades without dramatic changes in personnel. And even if there are changes in personnel, it's all luck of the draw, as I just got done saying. Scalia was on the court basically most of my life. And then he was replaced by another conservative. So it's like Scalia left, but a new conservative replaced him. So again, the court did not really change in its leaning. And that's what I'm trying to get at. One of the problems you're going to see for the court is it changes so infrequently in its actual demeanor that it's hard for the court to really do anything on its own, right? It's hard for the court to kind of break out and make a statement for itself, kind of separate from the government. Your book did mention that there was a bump in the court's approval rating in the 70s, and this does not show that, but I am showing that there's not dramatic shift in court approval ratings. But the court did get a bump in the 70s, the early 70s, and it's probably because everybody got to where nobody trusted the presidency, nobody trusted the Congress, but the courts came out looking good from Watergate because they were the person who basically killed Nixon. Nixon fought tooth and nail, and the Republicans backed him, and it was the courts that basically told Nixon, give us the tapes, stop playing games, you're done. And people were like, thank God the Supreme Court there was to save the day. And so the court actually was able to do something on its own that made it popular. But that's a glaring exception to the rule. 9 times out of 10, the court is going to be handed a case involving a law, and they're going to have to make a ruling, and half of America is going to like the ruling, and half of America is not going to like the ruling, right? And so that's why the court kind of ends up in this middle ground area, right? There's not a lot of dramatic shifts that can occur for the court. So the court is going to kind of be middle of the road, honestly, when it comes to public opinion. I realize you're like, 60-40. Yeah, but 10 points around, 50%, right? Meanwhile, when we talked about Congress the other couple chapters back, congressional approval ratings are usually like 20%, right? That's pretty dramatic. And as we've talked about presidential approval ratings, they will jump all over the place. The court kind of runs middle ground, right? And even when it's in a low approval rating, it's in the 40s, right? A high one's like in the 60s. Nothing dramatic. And as I say, the court doesn't change dramatically. It's going to take a lot of things to line up. You got to get the right people in there, right? The Warren Court, which was probably the most influential court of the 20th century, a very activist court. And they started the trend towards activism, judicial activism. And there was an attempt by Nixon and Reagan to reverse that. Every time Reagan and Nixon got a chance to put somebody on the court, they tried to put somebody that was less activist. They tried to get somebody that was a little more, conservative in their approach to how they interpreted the Constitution, etc. And they did succeed to an extent. Kennedy and Rehnquist and Scalia, they were all less inclined to try and take that broad view. But they weren't able to totally take that out. As I mentioned previously, Justice Blackmun wrote the decision that made abortion, basically that made anti-abortion laws unconstitutional. Berger upheld school busing. All those Reagan appointees had a chance to overturn abortion. And Justice O'Connor, the first female on the United States Supreme Court, she upheld the right to abortion. And so the Supreme Court, even though personnel has changed, that trend toward judicial activism that started in the mid-50s with the Warren Court, it's still kind of there, although there is, as your book noted, a deference towards Congress and the president. It seems like the court is a little less willing to take on the laws of Congress or presidential policy. They will overturn they will overturn a lot of things, but there does seem to be, the activism is held for certain specific areas, it appears, in the court in recent decades. Now, I do want to point out one reason why the court has gotten more activist in the last 60 years, and this is where we'll wrap things up. The court does a lot more because government does a lot more, right? Think about it. 100 years ago, the court didn't have to answer questions about farm subsidies and government programs and Social Security and Medicare and Obamacare and Great Society programs and all these things. We didn't have all these issues. And 100 years ago, something we talked about when we talked about civil rights and civil liberties. Everybody was like, yeah, we're all Christian, we're all religious, yay. Nobody questioned whether you should be allowed to put a manger scene in front of the public schoolhouse. Nobody talked about prayer in school. Nobody talked about abortion. Nobody talked about gay marriage. Basically, as government has grown and the diversity in society has grown and all sorts of other things have grown, the courts have to get in there. Because all these people are asking questions and nobody can agree, and somebody's got to serve as the arbitrator. Somebody's got to be the final voice in all these things. And so that's where the court gets drug in. All right? And it's the court's there to solve that problem. Whether you like it or not, that is the view many people, including the courts, have taken. The elected officials can't seem to come to an agreement, so I guess we'll have to come up with an answer. As your book tried to leave it, Congress can sort of control the courts, but it's rare that Congress takes on the courts after they make a ruling, because basically they are kind of put on this pedestal of that is what they are supposed to do. That is their role in our government. When these guys can't come to an agreement, it's these guys' job to come up with a solution.